Best part? I was sitting in my F-150 in the parking lot of Meridian Health Solutions on a gray Wednesday morning in November, watching the snow come down on the Trans-Canada, drinking coffee from a Tim Hortons cup that had gone cold 20 minutes ago. My phone was on the dashboard. My laptop was open on the passenger seat, and somewhere up on the 14th floor, in a glass-walled boardroom with a view of the Calgary skyline, the entire ARIA patient data platform, 11 years of my life, built line by line from a government contract worth $240 million, was going dark. I wasn't angry anymore. That part had come and gone. I was just watching. Let me back up, because to understand what happened that morning, you need to understand what ARIA actually was, and what it cost to build something like that in this country. I'd spent most of my career in health informatics. Before Meridian, I'd done 8 years with Alberta Health Services, the kind of government work that nobody talks about at parties but keeps the whole system running. Data integration, interoperability protocols, the invisible plumbing behind electronic health records. I wasn't flashy. I wasn't the guy pitching at conferences. I was the guy who showed up at 6 in the morning when a hospital scheduling system went down in the middle of a blizzard and stayed until it came back up, regardless of what day it was. When Meridian brought me on as principal systems architect in 2013, the company was a mid-sized health tech firm out of Calgary with decent provincial contracts and ambitions that were a little bigger than their technical capability. My job was to close that gap. And I did. Over the next decade, I built ARIA, Adaptive Resource and Integration Architecture, from scratch. The name was my daughter's idea. She was 12 at the time and thought it sounded important. She was right. ARIA connected 14 regional health authorities across Alberta and BC. It managed patient record synchronization across more than 300 facilities. It handled real-time bed allocation, pharmacy chain integration, lab result routing, physician scheduling. When COVID hit in 2020, it was ARIA that let the province track ICU capacity in near real time. The health minister mentioned it in a press briefing. Nobody mentioned me by name, but I was watching from my home office in Cochrane, and I remember my wife squeezing my shoulder and saying quietly, "That's yours." The intellectual property was a complicated thing. When I first joined Meridian, my employment contract had a standard IP assignment clause. Anything built on company time, using company resources, belonged to Meridian. I'd signed it without thinking much about it, the way you sign things when you're 34 and excited about a new job. But here's what nobody at Meridian accounted for. I'd started building the core of ARIA before I joined them. I'd spent 2 years developing the foundational routing architecture, what I called the adaptive mesh layer, on my own time, in my own basement, as part of a research project I'd been doing independently. I had dated source code repositories. I had time-stamped documentation. I had a provisional patent application that my brother-in-law, who's an IP lawyer in Edmonton, had helped me file in 2012, a full year before I signed anything with Meridian. When I joined the company, I'd licensed that core technology to them. Specifically licensed it, not assigned it, under a separate agreement that my brother-in-law had negotiated. The licensing agreement was clean, properly registered, and sitting quietly in a filing cabinet for 10 years while everybody at Meridian forgot it existed. Everybody except me. Now, the CEO's name was Gordon. Gordon had started the company with his brother 20 years ago, built it up slowly, and earned the right to be proud of it. I respected him for a long time. He was direct, he paid fairly, he trusted his people. The Gordon I worked for in 2013 was a good man. The Gordon of 2023 was a different story. It started when his son-in-law joined the company. The son-in-law, I'll call him the son-in-law because that's how I always thought of him, was 29 years old, had a business degree from a school in Ontario I'd never heard of, and had been running a lifestyle content business on Instagram and YouTube for the past 4 years. Motivational posts, productivity content, the kind of stuff where a guy in an expensive watch tells you to wake up at 5 a.m. He had about 300,000 followers and a very high opinion of himself. Gordon brought him in as Chief Innovation Officer, a title that hadn't existed at Meridian 24 hours before the son-in-law arrived. I told myself to stay calm. I'd seen companies go through nepotism phases before. Usually the family hire gets bored after a year, collects a salary, and largely stays out of the way of people who actually know what they're doing. I went back to my work. I updated the ARIA 4.0 roadmap. I had 3 provincial contracts to renew by Q1. Then the son-in-law came to my office. He sat down without being invited and looked around at my whiteboards the way people look at menus in languages they can't read. He said he'd been reviewing the company's digital strategy and he thought ARIA had enormous untapped potential as a public-facing platform. I asked him what he meant by public-facing. He said he meant consumer-facing. He had this idea that Meridian could pivot part of the ARIA infrastructure toward personal health tracking, connect it to wearable devices, let individual users see their own data, build a community around it. He talked about B2C monetization. He talked about engagement metrics. He said the healthcare sector was sleeping on influencer integration. I let him finish. Then I explained, as calmly as I could, that ARIA operated under strict provincial privacy legislation, that patient data was governed by PIPEDA and the Alberta HIA, that what he was describing would require regulatory approval processes that took years, not quarters, and would almost certainly violate the terms of our existing government contracts, that the entire foundation of the system was built on the trust of health authorities who had handed us access to sensitive medical records for specific, regulated purposes. He looked at me the way people look at someone who's being deliberately unhelpful. He said, "I think you're being a little rigid about this." I said I thought I was being accurate about this, which was different. He left. I thought that was the end of it. It wasn't. A week later, Gordon called me into his office. I'd been in that office 100 times. I knew the photo on his desk, him and his wife at Banff, probably 15 years ago, both of them squinting into the sun and grinning. I knew the view from his window, the way the light came off the Bow River in the afternoon. I sat down in the chair across from him, and I could tell immediately that he wasn't comfortable. He wasn't looking at me the way he usually did. He said the company was moving in a new direction. He said the son-in-law had put together a very compelling vision document. He said he needed me to bring the son-in-law fully up to speed on ARIA, full system access, full architecture documentation, administrative credentials. I said I needed to understand what full access meant in terms of what changes the son-in-law would be authorized to make. Gordon said the son-in-law was Chief Innovation Officer and would have authority to explore new use cases for the platform. I said that some of those use cases could put our provincial contracts at serious risk. Gordon said he appreciated my concern and that legal would be involved in any major decisions. I said that wasn't a sufficient safeguard for what I was hearing. Gordon's expression shifted slightly. He said, "I need to know if you're a team player, Neil. My name is Neil. I've been Neil for 51 years. I'd been Neil at Meridian for 11 of them." And in that moment, hearing my name said that way, like a warning, I understood that the conversation had already been decided before I walked in. I told Gordon I couldn't in good conscience hand full administrative access to someone without the appropriate background, training, or regulatory awareness. I told him that if the son-in-law wanted to be briefed on ARIA's capabilities from a high level, I was happy to prepare a proper overview document. But I wasn't going to hand over system credentials that govern the medical data of several million Canadians to someone whose primary professional experience was posting productivity videos on the internet. Gordon said he was sorry to hear that. I was back in my own office for 40 minutes before HR knocked on my door. They were decent about it, actually. The HR director had been at the company almost as long as I had. She looked uncomfortable and professional at the same time, which I imagine is part of the job. She told me my position was being eliminated effective immediately. She had a package. 3 months severance, which was below what I was entitled to under Alberta employment standards for my tenure. And I made a note of that. She asked me to hand over my access badge and sign a separation agreement before leaving the building. I did not sign the separation agreement. I told her I'd have my brother-in-law review it and respond within the statutory period. She nodded like she'd expected that. I packed my personal items into a box. Coffee mug. A photo of my daughter at her university convocation. A small fossil my son had found at Drumheller when he was 7 and given to me as a paperweight. I carried the box down to the lobby, pushed through the glass doors into the cold, put everything in the back of my truck. Then I drove to the Tim Hortons on 16th Avenue, ordered a large double-double, and sat in the parking lot and made a phone call. My brother-in-law answered on the second ring. I told him what had happened. There was a pause. Then he said, "Neil, do they still not know about the licensing agreement?" I said, "Nobody's brought it up." He was quiet for a moment. Then I heard him exhaling slowly. He said, "Okay, don't do anything yet. Let me pull the file." I want to be honest about the weeks that followed, because I've heard versions of these stories where the protagonist is perfectly calm and strategically brilliant, and everything goes exactly to plan. That's not what it was like. It was a difficult stretch. I'd given 11 years to that company. My daughter had grown up hearing about Aria at the dinner table. My wife had put up with the late nights and the weekend calls and the one Christmas Eve I spent on the phone with a hospital in Lethbridge because their integration with our system had failed and patients were being redirected. You don't walk away from something like that without feeling it in a way that's hard to describe. I also want to be honest that there was a point around week 2 when my daughter sat down with me at the kitchen table in Cochrane and asked me if I was okay. She's 23 now, finishing her master's in public health at the U of C. She said, "Dad, when they let you go, were you scared?" I told her I was a little. That it was one thing to believe you're doing the right thing and another thing to live with the consequences of it. She thought about that. Then she said, "But you didn't do anything wrong. You just didn't do what they wanted." And I said, "Yeah, that's usually how it works." She nodded slowly. "So what happens now?" What happened now was that my brother-in-law had been doing his job very quietly for about 3 weeks. Here's what Meridian had apparently overlooked in the chaos of restructuring their senior leadership. The original licensing agreement I'd signed with them in 2013 contained a reversion clause. The adaptive mesh layer, the foundational routing architecture at the core of Aria, was licensed to Meridian for commercial use under specific conditions. One of those conditions was that the licensing party, meaning me, had to remain as the designated technical steward of the system. The clause had been written deliberately by my brother-in-law with this exact kind of situation in mind. If I was removed from that role, whether by resignation, termination, or restructuring, the license entered a 60-day suspension period, after which reversion rights would trigger unless a new technical steward was formally approved in writing by me. Meridian had terminated me. They had not secured my approval for a new technical steward. They had not apparently read the licensing agreement in the 10 years since they'd signed it. Their legal team had turned over twice in that period. The person who had originally reviewed the agreement was long gone. My brother-in-law sent a formal notice of license suspension to Meridian's legal department on a Thursday afternoon in November. He copied the Alberta Privacy Commissioner's office because some of the data integration protocols were subject to regulatory compliance requirements tied to the licensing terms. He also sent a courtesy copy to the 2 provincial health authorities whose contracts were up for renewal in Q1. The phone call started the next morning. Gordon called me directly. That surprised me. I'd expected it to go through lawyers. But he called from his personal cell, and when I picked up, he sounded like a man who had not slept. He said, "Neil, I think we need to talk." I said I agreed. He said he wanted to understand what it would take to resolve this. I told him I was happy to walk through the options, but that I'd be doing it with my brother-in-law present on my behalf. Gordon agreed. We set a meeting for the following Tuesday at a coffee shop in Kensington, neutral ground, which I appreciated. The meeting was 3 hours long. I won't go through all of it, but I'll tell you that the son-in-law was not invited and his name came up only once, near the beginning, when Gordon made a brief and somewhat pained reference to having perhaps moved too quickly on certain personnel decisions. I didn't press on it. It wasn't the point. The point was this. Aria needed a licensed technical steward. I was the only person whose approval would satisfy the reversion clause, and I had conditions. The first condition was a fair separation settlement, proper pay in lieu of notice under Alberta employment law, full pension continuity, and a reference letter that reflected my actual contributions to the company. Gordon's lawyer had that to us by end of day. The second condition was that any future changes to Aria's data integration protocols required review and written sign-off from a qualified health informatics professional. Not necessarily me, but someone with actual credentials in the field. This was about protecting the health authorities and their patients, not about me maintaining control. Gordon agreed to it without much pushback, I think because he understood by then that his son-in-law's vision document had nearly cost him 2 provincial contracts worth $80 million combined. The third condition was a formal licensing renewal, Updated terms, fair market rate, properly reviewed by both sides. My brother-in-law had prepared a draft. Meridian's lawyer looked at it, proposed a few changes, and we had a signed agreement within 2 weeks. I approved their new technical steward, a woman named Dr. Okonkwo, who had come up through health informatics at the University of Alberta and had more relevant credentials than anyone else at Meridian. I'd actually recommended her for a position there 2 years earlier, and they hadn't moved on it. The irony wasn't lost on me. There's something I keep coming back to when I think about all of this. The morning I drove away from Meridian with my box of things, I stopped at the Tim Hortons and sat there for a while before I called my brother-in-law. I sat there and I thought about the 11 years. The ICU tracker during COVID. The night in 2019 when a hospital in Grande Prairie lost connectivity, and I stayed on with their IT team until 3 in the morning walking them through a manual failover. The version history in my personal repositories, hundreds of commits going back to 2011, each one a small problem solved, a small thing made better. I thought they can fire me from the job. They cannot fire me from the work. That was the thing the son-in-law never understood, and maybe Gordon had forgotten. That systems like ARIA don't come from titles or org charts or vision documents. They come from someone caring enough to stay on the phone at 3 in the morning during a prairie winter because patients in a hospital somewhere are depending on something working correctly. You cannot shortcut that. You cannot influencer your way into it. You cannot hand it to someone because they married into the right family. My daughter texted me the night after the Kensington meeting. She'd seen me come home looking lighter than I had in weeks. She wrote, "Dad, did it work out?" I wrote back, "Yeah, it did." She sent back a single word, "Good." Then, after a pause, another message. "I told you integrity wasn't free. But it also doesn't expire. She's going to be just fine, that one. Better than fine. I'm back consulting now. Independent, my own firm, working with a couple of First Nations health authorities in northern Alberta on data sovereignty frameworks. The work is harder in some ways and easier in others. I set my own hours. I drink better coffee. I don't have a parking pass anymore, which sounds like a small thing until you've spent 11 winters circling a downtown parkade at 7:30 in the morning. Meridian renewed the ARIA licensing agreement, and they are, by all accounts, running the system responsibly under Dr. Town Okonkwo's stewardship. The son-in-law left the company 8 months later to pursue a podcast. I genuinely wish him well. Some people find the right lane eventually. Gordon sent me a short email last spring. No subject line. It said, "I should have handled that differently. I know that now, for what it's worth." I read it twice. Then I replied, "It's worth something. Take care of yourself, Gordon. Because at the end of it, that's all you can really do. You do the work right. You protect the people who are depending on things working. You don't hand the keys to someone who doesn't understand what the keys open, and when they try to push you out for it, you stand still. You wait, and you let the thing you built speak for itself. That's the part they never see coming." I've thought a lot about that November morning, sitting in the Tim Hortons parking lot, cold coffee, snow on the windshield, watching the traffic move on 16th Avenue like nothing had happened. 11 years. And it ended before 9 o'clock on a Wednesday. What I keep coming back to is this. None of it would have gone the way it did if I'd made one different decision back in 2012. Not a dramatic decision, just a quiet one. Filing a provisional patent application with my brother-in-law's help, keeping clean records, writing a licensing agreement that said exactly what it meant. I wasn't thinking about leverage at the time. I was thinking about doing things properly. That's the part that gets lost in these kinds of stories. The protection didn't come from being clever or calculating. It came from having done the work honestly, from the beginning, and keeping track of it. That's what I'd call the first thing. Doing right by the work itself, even when nobody's watching and there's nothing immediately at stake. Gordon's son-in-law had a vision document and a follower count and a title that didn't exist the week before. What he didn't have was any of that, and in a field where decisions affect people's medical records, their care, their privacy, that gap matters in ways that don't show up in a pitch deck. The second thing is harder to talk about because it sounds like I'm patting myself on the back, and that's not what I mean. When I walked into Gordon's office that morning, I knew what I was walking into. I knew what "are you a team player" meant. I knew what the HR knock on my door was going to sound like. And I said no anyway, not because I was brave, but because I understood the system well enough to know what the consequences of saying yes would be. Not consequences for me. Consequences for the health authorities, for the patients, for the contracts that 300 facilities were depending on. Knowledge that's actually grounded in something. Not just credentials on a wall, but years of real, unglamorous, 3 in the morning problem solving. That knowledge carries a responsibility. You can't unknow what you know. You can't pretend the risk isn't there because saying so would be easier. And then there's the staying power of it. The weeks after I left Meridian were not easy. I'm not going to dress that up. 11 years is a long time to invest in something, and losing it in a morning leaves a particular kind of quiet in the house. What got me through wasn't anger. Anger burns off fast and leaves you tired. It was just continuing to show up. Calling my brother-in-law. Reviewing the licensing file. Sitting at the kitchen table with my daughter and being honest with her about being scared. Putting one foot in front of the other while the legal process moved at the pace legal processes move. Gordon sent me that email last spring. No subject line. Just, I should have handled that differently. I've reread it a few times, not out of satisfaction, but because it said something true. When you get that kind of acknowledgement, you realize the other person has done their own reckoning. That's not nothing. My daughter said integrity doesn't expire. She's 23 and she's already figured out something it took me until my 50s to really understand. The work you do carefully, honestly, and with real knowledge of what's at stake. That work doesn't disappear when someone signs a termination letter. It stays in the system. It runs in the background. It keeps the lights on in hospitals during Alberta winters. And eventually, one way or another, it speaks for itself.